ಇಲ್ರೆ. ಫರ್ಗೆಟ್ ಸಿಂಪತಿ, ಅಟ್ಲೀಸ್ಟ್ ಎಂಪತಿ ಬೇಡವಾ? ಎಂಪತಿ ಬೇಡವಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಫರ್ಗೆಟ್ ಸಿಂಪತಿ. ಇನ್ನೊಬ್ಬರ ಮನೆ ಮಗಳು ಹೋಗ್ಲಿ, ಇನ್ನೊಬ್ಬರ ಮನೆ ಮಗಳಾದ್ರೆ ಇವ್ರಿಗೇನು ಟೋಟ್ಲಿ ಅನ್ಕನೆಕ್ಟೆಡಾ? ಇವ್ರ ಮನೆ ಬಳಬೇಕಾಗಿರೋ ಸೊಸೆ ಅವಳು ತಪ್ಪಿಸ್ಕೊಂಡಿದ್ದಾಳೆ ಅಂದ್ರೆ ನ್ಯಾಚುರಲ್ ರಿಯಾಕ್ಷನ್ ಏನಿರ್ಬೇಕು? ಬರಿತೀನಿ ಅದಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಕಾಶನ್ ಮಾಡಿದೆ, ಬೇಡ ಅವೆಲ್ಲ ಅಂತ. ನೀವು ಕೇಳಿಲ್ಲ. ಇನ್ ಕೇಸ್ ಆಫ್ ರಾಜೀವ್ ಕುಮಾರ್, ದೇರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ were of the opinion that the medical report having regard to the nature of injuries sustained by the victim, where the victim died on account of the burn injuries, took into consideration about the role of the accused and then decided that he had no proximity with the time or the incident, and therefore were of the opinion that such person should not be made to stand trial. Facts of the case in the present case are altogether different. In fact, according to the prosecution, based on the voluntary statement given by the accused, the important circumstance, namely the place of dead body being found, is recovered by the investigation agency. Ali statement of the voluntary statement of accused number 1, important circumstance in the prosecution case, namely the detection of the crime and place of dead body being found, is recovered by the police. Pusta next para. The incident admittedly has taken place on 16th November 2021, and when there was a call made by the complainant to the present petitioner on 16th evening and again on 17th morning, there was a passive response from the present petitioner. Pusta. Deceased is none other than the daughter-in-law of the second accused and daughter-in-law of the second accused. First, if not sympathy, at least empathy should have been there with the conduct of the present petitioner in searching the dead body, in searching the missing daughter-in-law. First, the conduct shows that he did not care to find out what has happened to his own daughter-in-law. First, further, the circumstance that the first accused said to have committed the attempted to commit suicide is intimated by the second accused to the complainant in a very casual manner. When there was a call made by the complainant to lodge the complaint about the missing complaint about his daughter, second accused, as a normal prudent person, should have accompanied the complainant in lodging the complaint, or for that matter, first accused being the husband of the deceased should have accompanied, if they are so innocent as is sought to be portrayed. Full stop. But the second accused says that his son, that is the first accused, has tried to commit suicide. Full stop. Even that answer was in a very casual manner. Full stop. No details are forthcoming as to whether the first accused was taken to the hospital. Full stop. No other material is also forthcoming from the application of the second petitioner as to what is the normal prudent person would behave if his son has tried to commit the suicide. First, in other words, as could be seen from the material on record, probably the first accused must have revealed what happened on 16 to the second accused, and therefore they were fearing to visit the police station. Anyway, this court at this stage cannot form any definite opinion, as it would affect the rights of the parties during the trial one way or the other. First, moreover, what is to be looked into At this stage is the prosecution material itself, and it is for the accused to rebut the presumption available under section 113A and 113B of the Evidence Act after the prosecution discharges the initial burden in the trial. First, suffice to say that when the dowry amount has been received, material on record would go to show that the second accused is part of the crime in as much as he has received the dowry amount and materials have been collected, this court at this stage cannot hold a mini trial to find out whether the second accused is totally innocent. Coming to the question of the decision of L. Krishna Reddy, learned counsel for the revision petitioner drew the attention of this court to paragraph number 5, wherein their lordships had the occasion to deal with the statement recorded by the investigation agency under section 161 CRPC. First, in the case on hand, not only 161 statement is available on record, but also statement under section 164 CRPC is available, which is part of the charge sheet material. First, therefore, the judgment of Krishna Reddy would not improve the case of the petitioner in accepting his request for discharge. First, in the case of Dattaraj, their lordships were of the opinion that exchange of the gifts would not per se amount to dowry. First, that is the settled principles of law, and that should be decided only at the end of the trial. First, in the case on hand, receipt of the money, that too by phone transfer, cannot be treated as a gift, that too after the marriage. First, therefore, the argument that is put forth on behalf of the petitioner that the judgment of Dattaraj would help his case cannot be countenanced in law. Next para. In view of the foregoing discussion having regard to the material collected by the investigation agency, in the light of the principles of law enunciated by the Honorable Apex Court in the case of Devendra Padi referred to Supra, this court is of the considered opinion that there are enough materials to frame the charge and accused has to stand for the trial and then discharge his burden by placing the rebuttal evidence in the trial. Taking note of these aspects of the matter, this court is of the considered opinion that the grounds heard in the revision petition are hardly sufficient to discharge the accused. Hence, following order, revision petition is meritless and hereby dismissed. It is made clear that the observations made by this court is for the disposal of the revision petition and shall not influence the learned trial judge in the trial one way or the other. Consolation prize.
Great. Lord had also pointed out to Joshinder Yadav.
Not necessary.
Please.
You saw that judgment?
Yes, ma'am.
Bindula Devi.
How?
She, my intern has also read it. He has also got lot of doubts. What one can see from Joshinder Yadav by the Honorable Apex Court is have some sensitivity of these type of matters. Honorable Justice Ranjana Prakash Desai, in that judgment while accepting the versions of the prosecution, bestowed on one aspect of the matter. If you have gone through the judgment carefully, there is an explanation to be offered by you. You means the Yadav there. Here the revision petitioner. ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಕಾಂಡಕ್ಟು ಬಾಗ್ಲಾಕೊಂಡೋಗ್ಬಿಟ್ಟಿರ್ತಾರೆ ಊರ್ಗೂರೇನೆ. ಅವ್ರ ಮನೆ ಸೊಸೆ ಸತ್ತೋದ್ರೆ ಎಲ್ಲರೂ ಬಾಗ್ಲಾಕೊಂಡೋಗ್ಬಿಡ್ತಾರ. I know police atrocity. For a moment I am not discounting that. But even before the police could come into scene, what is the conduct of this gentleman? ಯೋಚನೆ ಮಾಡಿ ನೀವು. ಏನೋ ಏನಾಯ್ತೋ ಯಾಕೆ ಹಿಂಗಿದ್ಯಾ ಅಂತ ಮನೆಗೆ ಬಂದಾಗ ಕೇಳಿದ್ದಾರೆ. ಅಯ್ಯೋ ಸಾಕಾಗೋಗಿತ್ತು, ಹಿಂಗಾಯ್ತು, ಅಲ್ಲಿ ಸಿಕ್ಕಿದ್ಲು, ಮುಗಿಸ್ಬಿಟ್ಟು ಬಂದ್ಬಿಟ್ಟೆ ಅಂತ ಹೇಳಿದ್ದಾನೆ. ಇವರು ಚೆನ್ನಾಗಿ ಮಂಗಳಾರತಿ ಮಾಡಿದ್ದಾರೆ. ಇಂಥ ಹಲ್ಕ ಕೆಲಸ ಮಾಡಿದ, ನಾಳೆ ನಾವು ಪೊಲೀಸ್ಗೆ ಹೋದ್ರೆ ನಮ್ಗತಿ ಏನು ಅಂತ. ಅವನ ಅವಾಗ ನಾಟಕ, ವಿಷ ಕುಡಿತೀನಿ ನಾನು ಅಂತ. ಹಂಗ ನಿಜವಾಗ್ಲೂ ಪೂರ್ತಿ ವಿಷ ಕುಡ್ದಿದ್ರು ಹೋಗ್ಬಿಡೋನು. ಸಿ ಎಮೋಷನ್ಸ್ ಬಂದ್ಬಿಡುತ್ತೆ, ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ರಿಮೋರ್ಸ್ ಇರ್ಬೋದು, ನೆನ್ನೆ ದಿವಸ ನೋಡಿ ಒಂದು ರಿಪೋರ್ಟ್ ಇದೆ. Some officer, IPS officer, his wife is admitted to some ICU and best treatment. Doctor ಬಂದು I am sorry ಅಂತ ಹೇಳ್ತಾರೆ. So much of emotions pull in. He opens his revolver and then commits suicide. ಇದಕ್ಕೆ ನಾವೇನು ಹೇಳ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಸ್ಪರ್ ಆಫ್ ದಿ ಮೊಮೆಂಟ್. ಗೊತ್ತಾಯ್ತಲ್ಲ, ಆ ಯಾರು ಕೃತ್ಯ ಮಾಡಿಬಿಡ್ತಾನೆ ಅವನು ಮಾಡುವಾಗ ಅವನಿಗೊಂದು ಉದ್ರೇಕ ಇರುತ್ತೆ. ಇಲ್ಲ ಇದಕ್ಕೊಂದು ಅಂತ್ಯ ಕಾಣಿಸ್ಬಿಡ್ಬೇಕು, ದಿನಾಗಿನ ಗೋಳಾಗಿದೆ, ಇವತ್ತು ಆ ಕಡೆ ಈ ಕಡೆಗೂ ಆಗ್ಬಿಡ್ಬೇಕು, ಆಗೋಯ್ತು. ವೆರಿ ನೆಕ್ಸ್ಟ್ ಮೊಮೆಂಟು ಹೆಣ ಕಣ್ಮುಂದೆ ಕಾಣುತ್ತೆ. ಅಯ್ಯೋ ಇದೆಂತ ಕೆಲಸ ಮಾಡಿಬಿಟ್ಟೆ ಅಂತ ತಲೆ ಮೇಲೆ ಕೈ ಹೊತ್ಕೊಂಡು ಕೂತ್ಕೋತಾನೆ. ರಿಪೀಟೆಡ್ಲಿ ಅವನ ತಲೆನಲ್ಲಿ ಐಡಿಯಾ ಬರುತ್ತೆ, ಇಂಥ ಕೆಲಸ ಮಾಡಿಬಿಟ್ನಲ್ಲ ನಾನು, ಅಯ್ಯೋ 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 ಅಂತ. ನನ್ನಂತವ್ನು ಇರಬಾರ್ದು ಅಂತೇಳಿ ಹಿ ಟೇಕ್ಸ್ ಎ ಡಿಸಿಷನ್ ಟು ಎಂಡ್ ಹಿಸ್ ಲೈಫ್. ವೆಲ್, ಅಗ್ರಿಯಬಲ್. Impact of the incident will trigger the pituitary here. ಇಲ್ಲಿರುತ್ತೆ ಪಿಟ್ಯೂಟರಿ ಅಂತ, ಎಂಡೋಕ್ರೈನ್. ಅಲ್ಲಿಂದ ಹಾರ್ಮೋನ್ಸ್ ಬರುತ್ತೆ. ರಿಪೀಟೆಡ್ ಆ ಥಾಟ್ಸ್ ಬಂದಾಗ ಸೂಸೈಡಲ್ ಟೆಂಡೆನ್ಸಿ ಕ್ರೀಪಿನ್ ಆಗುತ್ತೆ, ಹೋಗ್ಬಿಡ್ತಾರೆ. ಅವೆಲ್ಲ ಇಂಪಲ್ಸಿವ್ ಸೂಸೈಡಲ್ ಟೆಂಡೆನ್ಸಿ ಅಂತ. ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ರೆಡ್ ಮೆನಿ ಥಿಂಗ್ಸ್ ಆನ್ ಮೆನಿ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್. ಇಂಪಲ್ಸಿವ್, ಅದು ಬರ್ತಾನೆ ಇರುತ್ತದು. ಮಗಂಗೆ ಹೇಳಿರ್ತಾರೆ, ನೀನು ನಮ್ಮ ಕುಲದೀಪಕ, ಚೆನ್ನಾಗಿ ಓದಬೇಕು, ಚೆನ್ನಾಗಿ ಮಾಡಬೇಕು, ನಮ್ಮ ಮನೆ ಹೆಸರು ಬೆಳಗಬೇಕು, 100 ತಗೋಬೇಕು ಅಂತೆಲ್ಲ ಹೇಳಿರ್ತಾರೆ. ರಿಸಲ್ಟ್ ಬರುತ್ತೆ. ಹುಡುಗ ಪಾಪ ಚೆನ್ನಾಗೇ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿರ್ತಾನೆ, ಯಾವುದೋ 1-2 ಸಬ್ಜೆಕ್ಟಲ್ಲಿ ಫೇಲ್ ಆಗಿಬಿಟ್ಟಿರ್ತಾನೆ. ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನೋಡ್ತಾನೆ, ಮನೆಗೆ ಬರ್ತಾನೆ, ಅದೆಲ್ಲ ನೆನೆಸ್ಕೋತಾನೆ, ಕುಲದೀಪಕ ಅದು ಇದು ಅಂತೆಲ್ಲ. ರೂಮ್ಗೆ ಹೋಗ್ತಾನೆ, ತಕ್ಷಣ ಒಂದು ನೇಣು ಹಾಕೊಂಡು ಸತ್ತೋಗ್ತಾನೆ. ಇಂಪಲ್ಸಿವ್. ಇದು ಆ ಥರದ ಕೇಸ್ ಆಗಲ್ಲ. ಇಂಜಿನಿಯರ್ಡ್ ಕ್ರೈಮು. 15ನೇ ತಾರೀಕು ಟ್ರಯಲ್ ನೋಡಿದ್ದಾನೆ, ಮೋಟರ್ ಬೈಕ್ ತಗೊಂಡು. 16ನೇ ತಾರೀಕು ಅವತ್ತು ಗ್ರಾಚಾರ ಮೋಟರ್ ಬೈಕ್ ಕೆಟ್ಟೋಗುತ್ತೆ, ಇವಳಿಗೊಂದಿನ ಎಕ್ಸ್ಟ್ರಾ ಆಯಸ್ ಸಿಕ್ತು. 16ನೇ ತಾರೀಕು ಬರ್ತಾನೆ, ಚಿನ್ನಾರನ್ನ ಅಂತ ಮಾತಾಡಿಸ್ತಾನೆ, ಸ್ಕೂಟಿ ತರ್ತಾನೆ, ಇನ್ನೊಬ್ರದ್ದು ಯಾರ್ದೋ ಹೊಂಡಾ ಆಕ್ಟಿವಾ ತರ್ತಾನೆ, ಅದ್ರಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾನೆ. ನಿರ್ಜನ ಪ್ರದೇಶ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾನೆ, ಬೆಟ್ಟಕ್ಕೆ ಹೋಗೋಣ ಅಂತ ಹೇಳ್ತಾನೆ. ಅವಳನ್ನ ಕಾಲುವೆ ಹತ್ರ ಬಂದರೆ ಕಷ್ಟ ಆಗುತ್ತೆ, ಉಪಾಯ ಮಾಡ್ತಾನೆ, ಕೈಕಾಲು ತೊಳ್ಕೊಂಡು ಹೋಗೋಣ ಅಂತ. ಆಸೆ ಹೆಣ್ಮಕ್ಳಿಗೆ, ಇವತ್ತು ಸರಿ ಹೋಗ್ಬೋದು ನನ್ನ ಗಂಡ, ನಾಳೆ ಸರಿ ಹೋಗ್ಬೋದು, ಬೆಟ್ಟಕ್ಕೆ ಹೋಗೋಣ, ದೇವ್ರು ನೋಡೋಣ, ಕೇಳ್ಕೊಳ್ಳೋಣ, ಒಳ್ಳೆ ಬುದ್ಧಿ ಬಂತೋ ಏನೋ, ಆಸೆ ಪಾಪ ಹೋಗುತ್ತೆ. ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಕಾಲು ತೊಳ್ಕೊಳ್ವಾಗ ದಬ್ಬಿಡ್ತಾನಲ್ಲ, ಡರ್ಟಿ ಮೈಂಡ್ ಅಲ್ವಾ? ಅಲ್ಲ, ಯೋಚನೆ ಮಾಡಿ ನೀವು, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. Court is at this time is required to reconstruct the crime scene and step into the shoes and then see the circumstantial evidence. Recovery of a dead body at the instance of the accused. ಆಯ್ತಲ್ಲ, ಅದು ಸಿಗ್ದಲ್ನೇ ಇತ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಅರಿಯೋ ನೀರಲ್ಲಿ ಹೋಗ್ಬಿಡ್ತಿತ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಇಟ್ ವಾಸ್ ಎ ಕೇಸ್ ಆಫ್ ಕಾರ್ಪಸ್ ಡೆಲೆಕ್ಟೈ ಅಂತ, ಇನ್ಕಂಪ್ಲೀಟ್ ಕ್ರೈಮ್ ಅಂತ. ತುಂಬಾ ಜನ ಹೇಳ್ತಾರೆ ನಾನ್ ಟ್ರೇಸಿಂಗ್ ಆಫ್ ದಿ ಡೆಡ್ ಬಾಡಿ ಇಸ್ ದಿ ಕಾರ್ಪಸ್ ಡೆಲೆಕ್ಟೈ ಅಂತ. ನೋ, ದಟ್ ಈಸ್ ಪಾರ್ಟ್ ಅಷ್ಟೇನೆ. ಕಾರ್ಪಸ್ ಡೆಲೆಕ್ಟೈ ಆಕ್ಚುಲಿ ಮೀನ್ಸ್ ಎನ್ ಇನ್ಕಂಪ್ಲೀಟ್ ಕ್ರೈಮ್ ಅಂತ. ಅವರು ಬದುಕಿದಾರೋ ಸತ್ತಿದಾರೋ ಏನು ಗ್ಯಾರಂಟಿ? ಹ್ಯಾಡ್ ಎ ಅಕೇಶನ್ ಟು ಡೀಲ್ ವಿತ್ ದಟ್ ಒನ್ ಸಚ್ ಕೇಸ್. ಚಾರ್ಜ್ ವಾಸ್ ದಟ್ ಯಾರಿಗೋ ಒಬ್ಬ ಡಾಕ್ಟರ್ಗೆ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿರ್ತಾರೆ ತಂಗಿನ, ಅಕ್ಯೂಸ್ಟ್ ತಂಗಿನ. ಅವನು ಇದೇ ಥರದ ಬ್ರೈಡ್ ಬರ್ನಿಂಗು 304B ಆಗುತ್ತೆ ಕೇಸ್.